My name is Christian Carson. I am a probate attorney in the state of Ohio, and today I'm going to be talking about the probate process. So somebody may have passed away and you're looking for what you need to do next. Somebody has probably told you that you need to go to the probate court or get letters of authority or something like that. So what do? First thing, before you do anything else, and I've written it up here, wait 6 months. We have to wait 6 months after the date of death. Why do we do that? Because of creditors' claims. Creditors have 6 months from the date of death to make a claim against an estate. So that could be medical debt, that could be credit card debt, that could be somebody just owed, so the decedent just owed money to somebody. All those people have 6 months to make a claim against the estate. Now, just to be clear, that doesn't include mortgages, car loans, things that are attached to an asset, because they'll get their asset. They'll foreclose on the house regardless of this rule. But what we're talking about is the money or assets that are in the estate. Those creditors can't claim against the estate if they don't get their claim in 6 months from the date of death. That might seem unfair, but the reality is that creditors have the ability to open an estate themselves if nobody else is doing it. So if there's a really big claim and it needs to be dealt with or taken care of, then the creditor can go ahead and pay the fee, open the estate themselves, get appointed administrator or executor, and then serve the claim on themselves. But really what happens often is that somebody jumps the gun, they run out to the probate court, they file their application, and then shortly thereafter they get a notice of claim from Discover Card or whatever claimant. So rule is we wait the 6 months, we wait them out, and then after that we can just throw the claims in the trash. We don't have to pay them. All right, so we waited 6 months. Now what do we do? So basically the probate process, what we have to go through for the probate court, is divided into really 3 stages. So I call that the application stage, the inventory stage, and the account. These are all named after particular forms that we file with the probate court when we open an estate and when we try to close it. So we're opening it with this, we're closing it with this. So what's the application process? Well, somebody's got to be appointed as the fiduciary. That could be an executor of the will. If there isn't a will, then it's the administrator. So that's the nomenclature that they use at the probate court. What it means essentially is the probate court wants to appoint somebody who's in charge. They want to give somebody letters of authority. That's your ticket to getting things done, to stepping into the dues of the decedent, going to the bank and closing their bank accounts, transferring title to their cars or real estate. You need the letters of authority. But before the court will give them to you, you have to go through the process. So the process really in Ohio, there's some standard forms that you use. The first one is Form 4.0, we call that. 4.0 is the application to administer the estate. It basically, you take a wild guess at how much is in the estate in terms of dollar amount, and then you give the information about the decedent, where they lived, when they died, whether they had a will or not, and then may need to post a bond. So a bond comes from an insurance company. A bond is just a guarantee that you're going to do the job that the court has appointed you to do. So the value of the bond that's required it's twice the value of the personal property. So if there's $20,000 in the bank, it's a $40,000 bond. You don't need to come up with all that money out of pocket. You go to the insurance company and you ask them, can I have a bond for a probate case for $40,000? And I don't know if there's a standard way to charge it, but what I've seen, what my agent charges me is about 1/4%. So for a $40,000 bond, I'm paying, I think that's $100. It's not much, but you have to have good credit. I have a lot of clients that don't have good credit, and I tell them to go get the bond, and then they come back 30 days later and they say, I couldn't get it. That's not a problem because the attorney can become the administrator. And I often do that for clients. So oftentimes that works out better for everybody because I know what I'm doing when it comes to accounting for things. I can go to the bank, I know who to call, and sometimes it can go more smoothly. And I usually don't charge anymore for that kind of service rather than just advising whoever is the fiduciary. It saves a lot of time from having to chase people down for bank statements and receipts and so forth. But in any case, so the bond is often a sticking point. Now, if you have a will, there's some other things to do, but we'll get into that in a minute. So besides the 4.0, what you need is a 1.0. So a 1.0 is next of kin. I'll put an okay. So this is just a list of who's the next of kin of the estate. So we always have a space for surviving spouse. If there's a surviving spouse, they're obviously next of kin. Even if there is a surviving spouse, we also list the children. If there are any children, they have to be children of the person who died, not stepchildren. They wouldn't end up on this form. Now, if there are children, even if they're deceased children, we would stop there. But so basically, there's something called consanguinity. The concept is for another video, but essentially, when you have children, you don't need to go for any more next of kin because the children are going to inherit, or they would inherit if there wasn't a will. So maybe there's a will that says, I disinherit my children. I've seen it happen. But if there isn't a will, the children are going to inherit. So that's what we put on the next of kin form. Now, if there aren't any children, then we have to think about consanguinity. Okay, if there aren't any children, then we look for parents. Do we have parents who are living? No? Okay, then we go for brothers and sisters. Are there any brothers and sisters that are living? If there aren't, then we go with aunts and uncles. And if there aren't any aunts and uncles living, which believe it or not can happen, you go with the cousins. So whoever is the lineal descendant of those aunts and uncles. But the important thing to remember is that you don't list every single person that you can think of who might be related to this person. You only look at these levels of consanguinity. Children, if we have children, we stop. No children, parents. If there aren't any parents, then we keep going. So we keep going until we find the level that we find somebody who's going to inherit. So beyond that, okay, so if we don't have a will, then we're done. Now, if we do have a will, then we need a 2.0. A 2.0 is an application to probate the will. So this is where we attach the will. It has to be an original will. It cannot be a copy. A lot of people get tripped up because in this day and age, a lot of people don't save originals anymore, but that's the law in Ohio. It has to be an original will, wet signature on it. It's got to be witnessed by 2 people, and they have to not be interested in the will. So you can't give your part of your estate to one of the witnesses. That wouldn't be a valid witness. You need somebody who's not interested, somebody who's disinterested. So the application to probate the will is essentially just a cover page for the will, and it just gives a little bit of information about the will. It's the mechanism by which the probate court can basically sign up, okay, we agree that this is a valid will. We'll admit it to probate. So this is a concept that is why probate is named what it is. So the word probate means prove in Latin. So we're proving a will, really, when we're doing this. And so if it's valid on its face, the probate court will say, okay, looks valid, we'll admit it. And so then there is a 3-month period that anybody can contest it. So we have to send out notices. So at any given point in time, there's notices that need to go out. But the thing to remember about what to do here when it comes to notices is if we get everybody on this 1.0 to sign a waiver, then the probate court will just let it go through because everybody is in agreement, basically. This is the probate court's cheat sheet to figure out who is going to need to be notified of everything or who can either waive their right to administer up here to whoever's applying or waive notice of probate of the will. So if you get everybody together, have them sign these waivers, it goes a lot faster. What happens if we don't have waivers? What happens if 1 or 2 of these people on this Form 1 don't like you, they don't want to deal with the executor, or they think that the will is BS and they want to contest it. So they're going to be difficult. That happens too. So what happens is the court is going to set a hearing. So they will mail something out that says hearing date 2 months from now or something to that effect. And they will probably also order whoever applied up here to serve a notice on everybody in this 1.0. So that's by certified mail, return receipt requested, either that or you can get them to sign the waiver. And usually, if you get everybody to sign the waiver, they will cancel the hearing. But if not, it's essentially an opportunity for anybody interested, vis-a-vis the next of kin, to object to either this application to administer or this notice of application to probate the will. Most of the time, it's kind of smooth sailing. Somebody might show up and object, but the probate court's not going to listen to them if they don't have a valid reason for objecting. There's a number of valid reasons for objecting, but they're probably not applicable in 99% of cases. You know, sometimes, oh, maybe somebody's telling a lie on one of these forms. That's really the most common reason why anybody would object. So let's just say, you know, we go to the hearing, the court says, okay, we found that you served everybody properly and we don't have anybody who has a valid objection. We're going to go ahead and issue letters of authority. So that's what I mentioned before. We want these letters of authority. That is your ticket to getting things done with the probate court. You can now take these letters of authority to the bank and close accounts, get checks, open an estate account. So what we do is we open an estate account, we close all of the decedent's bank accounts, we get checks written from the bank, and then we deposit it into the estate account. Now we are done with this phase, we can move to the inventory phase. So what's the inventory phase? The inventory phase is a gathering of the assets of the estate. So once we have letters of authority and death certificates, we can go to the bank, get the bank accounts closed, we can get a title to the car, we can figure out how much real estate is out there, and we are going to make a report of the inventory to the probate court. So actually there's a form called a 6.0, and that is the inventory and appraisal. So we can have the court appoint an appraiser for any of the assets that we find, but for 95% of cases that we do, we don't use an appraiser because we're allowed to use the auditor's tax value for any real estate that we find. For the most part, anything else is readily ascertainable in value, so we know how much money's in the bank. We don't need an appraiser to tell us that. We can go on Kelley Blue Book and print off a value of a car, and we can use that as an appraisal. And so that, with the values that we find, we attach that to the 6.0 and we give the court a list of every asset that's in there. So we might have real estate, we might have bank accounts, we might have, you know, cars. There's all sorts of things that might go on there, but usually we don't put household goods on them. And the reason for that is that household goods, unless they're really valuable, maybe they've got Rococo furniture from the 19th century or something, maybe that's got value. If it does have value, then you ought to be getting it appraised. And if it does, but if it's not that unique, it's probably not worth anything. And the reason why is because you're going to have to pay somebody to administer an estate sale and then clean out the house. And most of the time, you're basically breaking even. And so that value of that household goods is kind of not worth dealing with at that point. And maybe you might get $500 out of it, but you could just as well sell the house with all the stuff in it, and you know you wouldn't have the expense of having to get rid of it. But what's important to remember about the inventory phase is that we don't want to be doing distributions yet. We can't be distributing assets before we do the inventory. The reason why is because the law says that a fiduciary, the executor, administrator, whoever, person in charge, is personally liable for any distributions they make before the inventory is approved. So if you go out and you start sending checks out before that inventory, and one of the beneficiaries complains and complains to the court, oh, that you didn't distribute the right amount of money, guess what? You're paying out of pocket. So best practice, always remember, this is for getting things in. You want to be gathering assets. You don't want to be distributing. We don't distribute until we're done with this phase, and until we know exactly how much is out there. Because guess what? Like, there's taxes. You may find that you have to pay some debts, like IRS debts. That stuff, you may not know about this at this stage, but you might know about this a couple months later. So, you want to make sure that we're keeping the assets safe here until this point. So again, there's a hearing. So we do the same thing as before. Once we file the inventory, then the court sets a hearing, and then you have to go ahead and serve the same people again. They have an opportunity to object. They set a hearing, and then if it looks good on its face and you've provided enough evidence, they'll usually let it go through. But some court clerks are pretty nitpicky, and they want to send things back because, you didn't get an actual copy of the car title. We need that. And so it might be a back and forth. This can be tricky because every court's different. So the court has now set a hearing, and they've gone through your inventory, and they've decided that the evidence that you provided is okay. So they approve the inventory. They will send out a notice that says the inventory is hereby approved. What do we do now? Now we're in the account stage. So this is when, hopefully, by the time we get to this stage, we've made a list of all the assets. It's right here. We have an accounting of all the money that's left in the estate account and anything that we have to pay out, vis-a-vis taxes, so forth. So what do we do here? First things first, calculate what we are going to distribute. So we end up we pay court costs first, so it's just expensive. And we pay funeral bill, so whoever paid the funeral bill is going to get reimbursed, and attorney fees if we have any. And then we distribute. So we distribute on the basis of either the will back here. What does the will say? Usually it'll say something like, I give it to my 3 children in equal shares. Great, well, basically then we figure out how much we're gonna have left after this, and then we make a list. Now, the thing to remember is, we don't wanna write checks just yet. We wanna do that all at once. The funny thing is about probate is it's a little different than you think it's going to be in the account stage. We make distributions first, and then we tell the probate court what we did. We don't ask them for permission. They don't wanna hear about it. You can ask them for permission and they'll tell you to kick rocks. They want to see the final account, and the final account is going to show what you did, and it's going to have evidence for what you did. So any expenses that you paid. They want to see canceled checks or receipts. Same thing with the funeral bill, canceled checks or receipts. Attorney fee, well, that one has a separate form that goes with that. And canceled checks for distribution. Some probate courts want to see receipts from each beneficiary that acknowledges that they've received the distribution. So we take this all together, and then we file the Form 13. So there's a 13-0, there's a 13-1, but the Form 13 is the account form. And it's basically, you start with the total value on the inventory, whatever the balance was here, and then we reconcile it down to 0. So what happened to the assets in the inventory? That's what we're doing on the final account. So if you distributed the real estate to the heirs, then we show distributed in kind. If we have money in the bank, well, we show expenses. We show the receipts. Where did the money go? Down to 0. Same thing with cars. If we sold the car, then we show that we got $500 for the clunker. Or if we distributed the car to one of the heirs or more of the heirs, then we show that it was distributed in kind, and we take the value off the inventory. So we're starting with the inventory balance, and we're reducing it to 0. We're demonstrating where the money went. Now, the account is done in a very similar way that the inventory is done. So we file this, and then the court sets a hearing. And that hearing is 30 days. We have to notify everybody, we have to send them the account, and then we have to, hopefully we'll get some or more of the heirs to waive notice of the hearing. And once that day 30 hits, if nobody's objected, then the court will hopefully approve your account. And if they do that, then you're done. We've already distributed. We've already paid the expenses. All we're doing here in this form is we're just telling the court what we did and giving everybody else an opportunity to review what we did. This will be public record. And if they have an objection, they can bring it here. Now, if they don't object by this date and the probate court approves the account, then they're out of luck. They don't have any opportunity to do that. So it's a relatively short period of time that anybody has to object. So sometimes the court will also take issue with whatever you did up here. Maybe the distribution doesn't seem to be in line with the will. So then they'll kick it back and they'll say, no, try again. Or they may call you up into a hearing and do a Zoom hearing or even in person, and they'll tell you in person what you did wrong and what they want you to see. So you're not off the hook until this final account is approved, and they will discharge you from your duties. The account is approved. If it's not approved, then you're still in the jurisdiction of the probate court as the fiduciary. That means that they can hold you in contempt of court if you don't follow the orders of the court, if you don't get these things in. They can remove you as the fiduciary and appoint somebody else as kind of the cleanup hitter, and that next fiduciary that gets appointed, the successor, can investigate what you did and try to figure out how to fix it. So you don't want to be in a situation like this. You want to make sure that it's done properly and not too soon. I always recommend that we get this done first. We inventory all the assets before we spend any money. And then once we figure out where the money needs to go, we write all the checks at once. We copy those checks, we attach it to the final account, and we send it off, and then we're done. But where people get in trouble is they'll start spending money right here when they get appointed. And then they realize at the end that, oh crap, I sent too much money to Sister Jill, and she's not giving me the money back. And I got a tax bill that needs to be paid, and we don't have any money left. That's why we wait. We don't spend a dime unless we really have to. We write all the checks up here at the very end when we're ready to close. And then it's all neat. All of the expenses happen at once. And it's a very clean picture for the probate court. And then they will approve the account, and then you're done. So hopefully this has been a useful overview of just in general how the probate process works. And check out my other video.